I will be talking generally about estate planning, but specifically about Malaysia-Singapore. To narrow it down further, this will mostly concern non-Muslims. You're probably here maybe because of general estate planning interest. What is the difference between a multiple will or international will? Multiple will is basically, as it says, you have a few wills. Usually each will cover a specific jurisdiction or several jurisdictions. For example, maybe you have two wills. The first will covers Malaysia-Singapore and the second will covers Canada. You can even have one will, which is an international will, which complies with all the jurisdictions in which you have assets. So if you have Malaysia, Singapore, and Canadian assets, you have the option of making one will that will cover and comply with the laws of Malaysia, Singapore, and Canada. There are a few considerations. So the first one is how complex your estate is. For Malaysia and Singapore, there's many similarities in the basic structure of the wills. But if you have a very complex estate, it's best to make one will for each country. Another consideration, other than complexity, is how efficient you want your will to be enforced. In general, multiple wills are able to be enforced a bit more efficiently because you can have Malaysian lawyers getting the grant of probate extracted in Malaysia with the Malaysian will, and then Singaporean lawyers at the same time getting the grant of probate extracted in Singapore with your Singaporean will. So you can run parallel. Okay, and then consider also safekeeping. When you wish to enforce a will, the court will want to see the original. Another aspect I want to talk about is how to safeguard your assets, specifically in Malaysia. But I think these tips are also applicable in general. If you can have good practice when you're still alive, it will prevent a lot of complication after death. How do you cancel your will? You cancel it through getting married, or you voluntarily revoke it by making another will. Okay, so tax considerations actually is very simple. So when you inherit assets from somebody under pursuant to the inheritance law, both Malaysia and Singapore, you won't be subject to inheritance tax. However, it doesn't mean that I want to sell it off means must be no tax, right? No, actually it's subject to the usual tax laws. Court procedures, just to clarify, you don't need court when you make wills. And if you've been appointed as an executor, you want to apply for a grant of probate, is usually in Malaysia 2 to 3 months if it's uncontested. An international will, the grant of probate obtained in Malaysia will maybe resealed in Singapore, or you have to get a fresh grant of probate in Singapore. And the Singaporean lawyers do that. Malaysian lawyers cannot be paid to filing in Singapore. We have no jurisdiction. What happens if you have unwilling executor? Okay, don't worry about it because they just need to renounce that right. And then if there are no executors left, means no substitute executors, etc. Beneficiary can easily apply for letters of administration with will annex. If there's no wills, then follow the Distribution Act.